Eh bien, bonjour et bienvenue. Hello and welcome. So I'm very happy to receive Katharina Pistor. Professor Katharina Pistor is the Edwin Parker Professor of Comparative Law at Columbia Law School and the Director of the Law School Center on Global Legal Transformation. Her research and teaching spans corporate law, corporate governance, money and finance, property rights, comparative law, and law and development. Her latest book, The Code of Capital, How the Law Creates Wealth and Inequality, published at Princeton in 2019. It was named one of the best books of 2019 by the Financial Times and the Business Insiders. The Code of Capital is a fascinating and expansive analysis of the role of law in capitalism. More specifically, the book demonstrates how various legal modules, private law, contract law, corporate law, are used to flip object, ideas, and promises to future payment into wealth-generating assets. The book therefore explains how wealth creation and accumulation, as well as increased inequality, directly derive from legal coding. Professor Pistor will have the floor for 45 minutes, and then a question period will follow. Thibaut Biscaï, postdoctoral researcher at the Centre de Recherche en Droit Public, will lead this question period. Katharina, the floor is yours.
Okay, thank you very much. Good afternoon, everyone, and thank you so much for the invitation to come to Montreal. It's my great pleasure to be here and to talk about my book. I understand that this is a mixed audience, so if you don't mind, I would just like to maybe have a show of hands. How many law students are in here? Okay. How many technologists? More computer science? One. Okay. Political science or social sciences more general? Okay. Okay, so I just want to pitch my talk so I don't lose too many, and I want to invite you to raise questions if there are any. Let me just introduce the core concepts of the book and how I implement these concepts by walking through some of the case studies that I discuss in the book. I will also highlight what I have not done, and maybe this will give us some opportunity to discuss other applications of the book. So the core idea of the Code of Capital is that capital is coded in law. So capital I define as a wealth-creating asset. And I'm essentially saying, give me any object, like a piece of land, give me any promise to future payment, or give me any idea, and with the right legal coding, I can transpose these things into wealth-generating or capital assets. So law is critical here, I argue, because law essentially embodies the institutionalized means of coercion. This goes back to the famous Weberian and other definitions of the state as an institution that has centralized the means of coercion. I just want to highlight already that, of course, even though we have centralized the means of coercion, access can be highly decentralized, and private litigation is one way in which private parties can mobilize the power of the state on behalf of their own interest, provided they have a right, provided they have standing in a court of law, but if you have that, then you can do that as well. So my fundamental question at the outset is, okay, what does law do? If we flip land or ideas or promises into a capital asset, what is actually the function of law here? And I introduce in the book 4 attributes that I believe were critical in coding these different types of assets that I already mentioned. I will come to more in coding them into law. One is law can give asset holders priority over other asset holders. So I can have stronger rights and others have weaker rights. If you think about bankruptcy, that's always, in my view, the asset test to figure out who has stronger rights. Because when the debtor is insolvent, by definition, the debtor has not enough assets to fulfill all claims. And so we need a rank order, who gets what. An owner, somebody who has just lent maybe her car to the debtor, can just take the car out. And all the other creditors have to stand aside and have to let her do so. Somebody who has secured that car, who has a collateral, can take it out before any of the unsecured creditors can take anything. And if you're an unsecured creditor, you typically walk away with a stiff haircut, right? So this is how law ranks rights. Some are stronger, some are weaker. If you have stronger rights, you win. If you are a lawyer for somebody who holds assets that they want to code into capital, assets with which they want to make a lot of money, you will try to use the law to make sure that they have priority rights in relationship to others. The second attribute of the Code of Capital is what I call durability, which is which can be done through different legal institutions, and I will explain them in a second as well. But durability basically creates incubators within which assets can grow over time because they're protected from too many different claimants. So not all creditors can put their hands on the assets of that are protected by durability features, such as a corporation or a trust, because, for example, the creditors of the owners can't reach into the firm and secure those assets. They can only reach the shareholder himself. The third attribute is universality, and that is critical because universality ensures that these rights that we create in law are protected against the world, erga omnes, as we like to say in Latinese. That means if these rights are recognized in law, or recognizable in law, and can be asserted as legal, then everybody has to yield whether or not they knew about the transaction or knew exactly whose rights were implicated. Most of these rights are created in private law through contracts, through transactions, but they will have effect against others as well. Convertibility, finally, is the way in which financial assets can attain something like durability. Financial assets are always being traded, and so it's not, you don't really want to lock them up. You want to be able to trade them. But if all financial assets go south in a financial crisis, for example, you want to convert them into safer assets. You want to have access, ideally, to state money, because state money tends to hold its nominal value, even in times of crisis. It may lose its real value, that's what we call inflation, but holding nominal value is absolutely critical in times of crisis, because all other private assets typically go south, and they go south together, which is why investors run for the exit, as we say typically. And what that means is that they try to get cash, state money, right? That's what they want. So then these attributes don't all operate together. I usually say you need about 3 of them to code capital, but they don't have to be identical. Universality is critical for all, but it could be priority and convertibility, or it could be durability and priority on the other side. Now, which are the legal institutions that do these jobs? And this was really the surprise for me when I started really thinking about these issues systematically, is when you look at the longue durée of capitalism, let's take the last 3 centuries or 4 centuries, it's been really only a handful of legal institutions that have been used time and again to code capital. Now, you could use others. I'm not saying this is restrictive, but you see them again and again and again. And they confer the kind of attributes that I discussed before onto different types of assets. Property rights, key. Collateral law belongs to the family of property rights. I mentioned already, if you're a secured creditor, you have better rights than unsecured creditors. The law of trusts, and I'm not sure why the pictures are not coming up here, but they don't, doesn't matter. Trust law is the common law trust, one of the most ingenious institutions that I think the law has brought about, because it allows you to change property relations through contracts. And to do this in a deed that might be sitting in the drawer of an attorney or a solicitor, and you can pull it out and say, oops, but this asset belongs to that beneficiary, even though nobody else had known this before. Corporate law, better known, it's a bit more public, but corporate law is also a critical function in creating durability, because the assets that belong to the corporation do not belong to the shareholders and cannot be seized by the creditors of the shareholders. They have to first liquidate the firm, and that's a more complicated process. Bankruptcy law I already mentioned, because bankruptcy also creates priority rights. Who can take things out first, who is last? It basically creates a kind of rank order, a kind of property regime only through bankruptcy law. It sits a little uneasily in this group of legal institutions because it's mandatory law in most jurisdictions. It's less malleable, less manipulable by attorneys than all the other elements. Contract law, lastly, of course, is very often thought of as just as a binary institution, but it can replicate or mimic many of the other institutions that I already mentioned. Okay, so I quote at the beginning of the book Bernard Rudden, a legal historian from England, who said something that I think really captures what this book is essentially about. He says the traditional concepts of the common law of property were created for and by the ruling classes at a time when the bulk of their capital was land. Land, I will show you a slide in a second, was the most important source of wealth until the end of the 19th century, even in Britain. Nowadays, he continues, the great wealth lies in stocks, shares, bonds, and the like, and is not just movable, but mobile, crossing oceans at the touch of a keypad in the search of a fiscal utopia. That's 1994. Today, of course, it's even faster. And then he says, in terms of legal theory and technique, however, there has been a profound and little discussed evolution by which the concepts originally devised for real property have been detached from their original object, only to survive and flourish as a means of handling abstract value. The feudal calculus lives and breathes, but its habitat is wealth, not land. And of course, it creates wealth, right? And it creates this with the same institutions. So the core assets that I discuss in the book that have been coded as capital over time are land, firms, debt, and know-how, including know-how about the genetic code. And we'll say a few words about each of the case studies I have in the book. So somehow the slides don't appear the way that I wanted them to appear. So this would have been a graph basically from Thomas Piketty's book, Capital in the 21st Century, where he shows in a graph that until 1880 roughly, 1881 to be precise, land was the most important source of wealth in England, and you can have similar graphs for different jurisdictions in the world. After that, it changed. And he discusses this in a chapter which he calls the metamorphosis of capital, but he only thinks about changes in demand and supply for land and maybe different goods. If you look into the legal history of England, you can actually explain the shift from land to other assets, and of course these are financial assets that then become much more important, through changes in the law. Because until 1881, the law of realty, the real property law of England, protected landowners against their creditors. So if you entailed the land, if you took your land and you basically said the owner is not really an owner, but it's just a life tenant that holds the land on part of future generations, then the creditors could never take all the land away, never the family mansion, and at most 50% of the rest of the land. That protected the family estates, so we had lots of big family estates in England. But of course, for creditors at some point, this was a little bit difficult, because if they didn't pay the credit back, what could they do? And lo and behold, in the 1870s, there was a big depression in agriculture, as a result of which several things happened. First of all, there were two new legal enactments, the Land Surveyance and the Land Settlement Act, and they basically said we will treat the life tenant as an owner, with the effect that the creditors can take their entire land away. And after that, we had a major reallocation of land in England on the scale that was similar to when the Catholic Church was pushed out of the country. So about 20% of all land changed hands within a relatively short period of time. Plus, it was the first time, that's why the acts passed, it was the first time that the landowners no longer controlled the majority in the House of Parliament. So there was a political shift that went, of course, hand in hand with the economic shift. So what I'm suggesting here, you can actually sometimes even look exactly at when legal change happens, that basically in this case has taken away durability from land. Because by entailing the land, by using something akin to a trust figure, and empowering families to hold on to the land, even though they were deeply indebted, they made their own wealth durable, to a point that agriculture almost collapsed, and then everything changed. So that can happen sometimes when we push the legal protections too far. We see this in finance all the time, but we can see this even in land. The system will crash, because if you enforce all the legal claims that have been made in the past under some assumptions that might not hold true today, then the system will self-destroy. Okay, the second, so here is a slide that works, it's nice. The second chapter that has a case study, is, you can see it already, is Leman Brothers. And here I discuss the role of corporate law. So this is a simplified version of how Leman Brothers looked like at the time it went under. You will recall perhaps that in September 2008, Lehman was pushed into bankruptcy. There were some hopes, especially by the management of the company, that somebody would bail it out, and either they would find another suitor or private bank that would buy them, or the government would give them the necessary resources, and the government said no. As a result of which, of course, we were pushed into a deep financial crisis, from which we recovered only because after saying no, the government said yes. When it came to AIG and all the other investment banks, they basically underwrote them. I use Leman Brothers because I think it gives us a sense of how a legal form that was once invented or was used, certainly during the ages of industrialization, as a way to pool resources, to pool capital from many investors, and then make important capital investments, how this legal construct was used as I say in the chapter, as a capital mint. How you can use the corporate form to diversify risk and structure finance internally within a company group such that you can make a lot of money for the shareholders, right? Even as you put the company itself at risk. So you have Leman Brothers Holding, which is incorporated in Delaware. There were other 60 additional entities that all belong to the group, also incorporated in Delaware. There were about 34 in England, there were 30 in the Cayman Islands, of course a tax paradise, some in France, Germany, Japan, Australia, but the major ones were in the US and the UK, and especially in Delaware. And one might ask oneself, why do they have so many entities? And of course, the subsidiaries were not the only ones. They also had lots of trusts or other special purpose vehicles. That's the jargon. Behind the jargon, we typically find a trust or a limited liability company of sorts. Why did they have so many entities? Right? It's not because they had to always open another subsidiary in a different jurisdiction, because if you have 60 entities in Delaware, then there's a different function. And I argue that the function was actually that they established a separate legal entity for each new financial instrument that they started to protect the rest of the company from something that might happen to that. So if one instrument doesn't really work in the market and the entity goes under, you just let this entity go into bankruptcy, but you protect the group. But at the same time, what they also did, they managed the entire group in a very sort of centralized fashion. All profits would always go back to the holding company at the top, and all of the profits were always given back to the shareholders through dividends and repurchasing programs. So the cash was always given back to the shareholders. They raised funding for the subsidiaries through debt, and the parent company guaranteed that debt. When you then look through the structure, you can see that the holding company had assets, but the assets were shares in companies that basically raised debt finance in the hopes that they could launch new products that would make a lot of money. But it was a house of cards that would have to crash once too many of these entities had financial assets that were no longer viable. And once the whole thing started falling apart, it became very apparent that the parent company could not guarantee all that debt, and so the whole thing folded, essentially. That's the story of Leman Brothers. But my point here is very often people said, well, why did this happen? They don't understand, because the top management themselves, they had shares in the company. Yes, but most of the shareholders made a lot of money. They very often cashed in a share repurchase program, then came back and bought new shares and cashed in again. They milked the company, right? They were not long-term shareholders. They milked the companies as all other investors did. And they did this in the expectation that the game would continue forever. And then it did no longer. But the point here is sort of you take a structure, the corporate law, which is made for durability, you flip it into a structure that shields different groups of assets against too many different claimants, and then you play the game of trying to raise debt finance and take the profits and you put it up to the parent company and then out to the shareholders. That's basically how it worked. The next chapter is what I call minting debt, asset securitization. You all know that one of the big financial innovations since the 1970s was securitization on a large scale of all kinds of different claims. Most importantly, of course, homeowner loans that were securitized, which basically means that you take a claim against the homeowner that basically commits to pay back a loan, and you take many claims against many different homeowners and you package them. So if you look into the right-hand corner from your perspective, the little houses are all in California, and you had New Century, a brokerage that would basically give loans to homeowners in California to buy houses. And they would do this 1,000 times, or 4,000 times in this case. Then they would take all the claims they now have against the homeowners. Each of them is secured. Think about a collateral as one of the modules of the Court of Capital. Each of them is secured by a mortgage. They package this all together, and then they sell the entire package to Citigroup. Citigroup doesn't take it at the parent level, but Citigroup has a separate entity that deals with these mortgages. They buy them, They don't keep them on their balance sheet, but then now they create a trust. And they put all these assets from this particular brokerage into that trust, also called, again, a special purpose vehicle. Here it's basically the round little thing on the left-hand side, that's the trust. And then they sell interest in the trust to investors. The investors are expecting the future cash flow that comes in because the homeowners pay their mortgages monthly. And they pay interest and they pay some principal, but the money comes in and the money goes out. Originally, when securitization was invented by the government-sponsored entities in the US, basically under the mandate of opening housing to also lower income families, the Fannie Mae and Ginnie Mae were doing most of the securitization. By the 1990s, the private sector had taken over effectively. And what they introduced was a way to tailor different claims against this trust to different investors. So some investors want to have some more safety, other investors are more risk-taking. They, of course, get different yields as they are, but they also might lose more. And so they tranched the claims against the trust. Basically, you had senior investors, or senior creditors, or senior tranche holders. They would always get the money first that came in, and they would always be the last ones who would have to bite the bullet and take some losses. And on the other side, you have the juniors. They would always be the last ones to get anything that came in, and they would always be the first ones to take the losses. And you had a lot of investors who wanted either one of those, either very secure or very risk-loving investors, but the mezzanine tranche was difficult to sell because it's neither here nor there. But unless you place all these tranches, the securitization machine doesn't work, because what they were doing is they were basically placing all these tranches all the time and then asking NC or New Century and other brokers to bring in more mortgages so they could do more securitization, because there were many financial intermediaries involved that made a lot of fees along the way. So you have to place the mezzanine tranches, and if you couldn't place them, what did you do? You just invented your own buyer. So you find some sponsor that sets up a company in the Cayman Islands, which goes out and tells investors, we will buy securities, we will buy securitized products for this entity, and you will get the cash flows. Now, the products that we are buying were rated by rating agencies as being more like BB, maybe B-. They're like mezzanine tranches. But if we buy a lot of them from many, many different trusts like this one, then diversification probability calculus suggests not all of them will tank at the same time. So we can rank some as A, maybe AA, not exactly AAA, but we can have senior and we can have junior. And we do this whole thing that I just described again. And if you, again, cannot place the mezzanine tranches, you just set up another entity, ideally in the Cayman Island because you save the taxes, and do this again. That's what we call basically collateralized debt obligations squared or cubed. That's what these things were. If you look at the legal structure, this is how they worked. And they made a lot of money for these banks, for many investors, for a long period of time. But again, like Leman, they're also kind of a house of cards, because if most homeowners at some point can no longer pay their loans, then the system collapses. The problem was that past experiences suggested that housing markets in the US would not all tank at the same time. Maybe in Florida, but not at the same time in California, right? But when they tanked all at the same time, when they flattened out in 2006, the market already started to crackle and then collapsed, was close to collapse, certainly in September 2008. So here you see at work, if you look at this, you see property rights, home ownership, collateral. This is the mortgages. You see the trust. You use the trust as a shield, so that the investors don't have to think about Citigroup when they invest, when they buy these tranches, because Citigroup is only basically a sponsor of this whole thing, doesn't do anything, just gets a fee. But the trust is separate from it, so you only have to think about the cash flow that comes into the trust. That's the idea of this whole structure. I also put the little flags in here to give you a sense that this is global, right? It starts in the United States. The UK also has a lot of securitization, other countries less so, but you have Bayerische Landesbank, a German state-owned regional bank. You have Fannie Mae buying into this. You have China Investment Corporation, the Chinese Sovereign Wealth Fund. You have BNP Paribas, all investing heavily into these structures. And BNP Paribas had to close some funds, and in 2007, Bayerische Landesbank was restructured. So many of them suffered badly at some point from this. The next story is about intellectual property rights. So I think intellectual property rights are always the best example to show that rights are created in law and don't exist outside of this. So we always think as land as property, but land as such is a piece of dirt. You can go and graze your cattle, you can collect some fruit from the land, you can go hiking or enjoying the land, but you can't monetize it. And capitalism is all about trying to extract the pecuniary, the monetary gains from different types of assets. Intellectual property rights have to be created to exist. They owe their very existence to law. They do not exist outside of this. Good example, the US Constitution. It says in several amendments, property rights are protected, but doesn't say where they come from and who defines them. But when it comes to intellectual property rights, it gives Congress the power to adopt laws that create intellectual property rights. And without that power, they would not exist. So that should be clear. Now, the question, of course, is then what can be patented? And there have always been principles that things that belong to humanity, things that belong to all of us, should not be patentable. Algorithms, ideas about colors, just some fundamental issues, and you would have thought also the genetic code. And yet, in 1994, a small little company in Utah was able to obtain a patent over the sequence of a gene that is responsible for causing one of the most aggressive breast cancers, the BRCA gene. Now, the discovery of the gene had been done by a consortium of publicly funded scientists at the NIH and Europe, etc. A whole consortium had identified the gene, but if you want to use it for diagnostic purposes and maybe for treatment, you have to know the sequence. You have to know exactly the bases that make up that part of the gene. And once sort of the scientists had published their papers about the gene itself, a little company found venture capitalists that funded them, and they basically raced against the NIH and other publicly funded organizations to be the first to find the sequence. And when they had the sequence, they went to the US Patent Office, and they got the patent. With the effect that they told all doctors who were diagnosing women and trying to test whether or not they had the BRCA gene, they sent them cease and desist orders and said, you have to use our kit because we have the patents, you can use only our kit, and by the way, you have to send us all the data because then we can test whether or not this woman has an aberration in her gene or not. Now, the story in the book revolves around the actress Angelina Jolie. She wrote an op-ed in the New York Times in 2013 where she disclosed that she had just undergone a double mastectomy because she was a carrier of the gene. She also disclosed that she had to pay $3,000 for that test. And that was the background of Myriad Company, the little company in Utah, having obtained a patent because they charged $3,000 for a test that doctors had done because they had found their own tests for $120 or $250 before. So at some point, patient organizations and doctor organizations and scientists got together and they went to court to challenge the patent. But this is also another important aspect of private law and the coding of capital. You code first and then others have to challenge you. You go out there with a patent, you at least have to convince the patent office. With other financial transactions, you set it up. And if somebody wants to challenge you, they bear the cost of doing that. So you have a major first mover advantage. So it took more than that. It took from 1994 to 2013, so close to 20 years, for the case to reach finally the Supreme Court in the United States. And luckily, it struck down most of the patent, not all of it, but most of the patent, arguing again, the genetic code is part of humanity and you can't just patent it unless you manipulate it. So to the extent that humans start manipulating the code, that manipulation itself is human ingenuity, and that in principle is patentable. They reaffirmed that as well in the case. But they struck it down, yet the company didn't really suffer so much. They had almost reached the end of the patent anyway, because they're only temporary monopolies. They had used the patent to build a monopoly over the data because by 2004, they stopped sharing the data with others. And so if you wanted to find out on a reliable fashion whether you have this cancer gene or not, you would go to a Myriad Company because the more data you have, the more reliable, of course, the tests are when you run these tests. So long story short, we have a story here where intellectual property rights have to be created by law. What can be patented or not is a case-by-case decision that is done by a patent office and then reviewed by courts if and when somebody challenges you. right? So once you have convinced the patent office, you can think about capture sometimes, but some, in the US in particular, there's a very pro-patent, has been a very pro-patent attitude. It has changed over time. Okay, so let me just step back a little bit. So you have these stories, and we can talk about more stories. I just want to say a couple of more, slightly more abstract things. So first of all, you know, what does this coding really do? And one of my colleagues put it very succinctly, basically saying law codes power, not justice. So in my book, The Code of Capital, law really codes power of private agents that have lawyers on their side that know how to use the law to code capital, to code interest. As I mentioned already, Max Weber and others have argued that the modern nation states has centralized the means of coercion, but you can access these means of coercions in a decentralized fashion. You can litigate. Sometimes you just wait to be litigated, but you can also aggressively litigate. And if you have the resources to litigate and to relitigate and to relitigate, if you're there in the long term, you also have much more sway over the direction of the evolution of the law. I already mentioned that the legal system is the institutionalized the institutionalization of the means of coercion. Now, access channels to these means of coercions, of course, vary. You can think about public regulation of criminal law. That's where public agents use that. But in private law, it's, of course, the civil courts. And then the question is, what are the civil procedure rules that give you standing in a court of law? So here just a couple of principles that you are familiar with if you are going to law. But it should be clear, not all interest can be brought to a court of law. Not all interests are justiciable. Only some are. If you have an individual right, like a property right, if you can claim a property right, you have a pretty good chance that you have standing. If you have relatively amorphous collective interest, it's not clear that you can necessarily go to a court of law. So there's some claims are permissible. Some people have standing. Other people don't have standing, and that already determines very how we can use the legal system to protect different types of rights. I will skip this because I want to just come to a couple of more important issues, and we can come back to all of this. 3 issues I still want to point out. One big question that comes out after you do the analysis of how different modules of the Code of Capital code capital over time. Of course, the question is who has done it. The second question that I would want to put on the table is how does this work in the global context? And the third one is how does this interface with our ideas of democratic self-governance? These are the big political economy issues in a way. So as you can already see, this is the cover from the Italian translation of the book. I put the attorney, that's how the attorneys look in, at least when they come to court in Italy. I'm basically saying the private attorneys are the masters of the Code of Capital. They do the coding. They kind of like, when I talk to them, they kind of like to be called masters, but they don't really like to have the responsibility that comes with agency of this kind. So what I'm saying is they're not only advising a client of what to do, what is legal, what is not legal. The best lawyers, the best paid lawyers are very creative people, and they use the law and use the malleability of the law to fashion new assets and interest on behalf of their clients. So I've been teaching for many years a seminar on law and finance with one of our trustees who is a practitioner, and she has securitized almost anything you can securitize in the world, and she also brought many of her clients and her partners to our seminar. And she explained to my students at the beginning, you have to think about when you want to create a new financial asset for your client, you have to think of the existing rules and regulations as the scaffolding, like the scaffolding you put around a building to secure it when you do renovations. And you have to fashion something that fits through the gaps of the scaffolding. Because if you hit one of the pillars, that means it's legally not defensible, it's void, and then it doesn't work. Because what you want to do is you want to claim it's legal. So you have to look at all these existing rules and regulations, sometimes also of multiple jurisdictions, and try to fashion something that fits through the scaffolding. That's how you create a new financial asset. That gives your client a comparative advantage over others. They are formally compliant with the law, Of course, they undermine the very purpose of the law very often, but you have to be caught on that, and that's a bit complicated. And that's basically what they do. And that they have done this from the early disputes over the enclosure in England in the 16th century, and they certainly have done this all the way to today. Most of these actions take place behind closed doors in the offices of law firms. Few of these issues are ever litigated because people do not take actions, certainly not as long as the markets are up, but also they are fearful of taking actions against powerful actors and actors that are also then advised by powerful law firms. The second point is that we're always talking about London and New York as being the global financial centers. What I'm saying is they're also the global legal centers of the world. They house most of the law firms, the top 100 global law firms. I have only 23 here. All of them, as you can see, have English names. They're either English or New York, and most of them sit either in London or New York. So in some ways you can talk about globalization as the globalization of Anglo-Saxon legal practices that is extended also by extending more offices in jurisdictions in continental Europe or elsewhere in the world. Now, you might ask a critical question about my entire argument by basically saying, you tell us that capital is coded in law. The law that you describe is private law, and private law is domestic law. And yet we have a global capitalist system without a global law and without a global state. Doesn't that undermine the entire argument? Yeah. So that's one fundamental question that you can ask. And my response to that is, in theory, we could have global capitalism that is supported by only one domestic legal system, as long as all other legal systems are saying we will recognize and enforce the law that is made by that state. These are what we call in law the conflict of law rules or international private law rules. Domestic legal rules that determine whether or not the law of a foreign country can be applied in a particular case or must even be applied and will be recognized and enforced. And what we have in the real world is not one legal system that sustains global capitalism, but predominantly two. And these are, of course, the UK and the United States. Most tradable financial assets are coded in English or American law. If you look at the International Swaps and Derivatives Association, everything that has to do with securitization and derivatives is governed by a master agreement that was drafted by them, and they basically tell their clients, their client members, take English or American law, take English or American courts. If you don't, the risk is on you because we can't predict what's going to happen. So that has a very strong, of course, consolidation force on that. I also ask in this book a question to which we might come in the Q&A, and which I hadn't mentioned before as an important question, of course. I do ask the question at some point, might it be that the legal code will be preceded by the digital code? Could it be that that the kind of power that I see in the law being exercised by private attorneys writing private transaction is slowly but surely going into the hands of technologists, people who write software codes or such as for ChatGPT, of course, which didn't exist at the time, and basically conquer another resource that determines how people relate to one another, who has more power than somebody else. What about the digital code? Now, in the book, I think this is the most dated chapter because I finished writing it at the end of 2018. And in the book, I suggest that I believe that probably at least for now, the legal code will still enclose the digital code rather than the other way around. I would today be a bit more cautious on this front, but we can discuss this later in the Q&A. So let me come then to the final issue, and that is, what about we the people? Democracies govern themselves through law. That's the whole idea, right? We create a constitution and we empower different agents, the legislature, indirectly maybe regulators, and maybe too much so today, but we have basically different government agents that are supposed to write the law on behalf of a public that is sort of a self-governing demos. And yet, when we look at the ways in which capital is coded in law, we can see that private actors can take the law into their own hands, and by pushing the limits of existing law, by trying to find new assets in the scaffolding of existing regulations by basically doing a lot of legal arbitrage, create new law that claims and very often, in fact, is enforceable in different courts of laws. And on top of that, they can pick and choose from different jurisdictions around the world the one that best fits their interest. And by picking and choosing, they're basically opting out of one legal system and opting into another one without necessarily having to move. Right? I can bring Cayman Island tax-protected corporations to the United States, and they will be recognized as corporations. Right? That gives you the opportunity to opt out of the legal system in which you are operating, but most other people cannot do this because it requires a lot of sophistication and money to be able to do so. So at some level, I think the coding of capital, especially as more and more assets are being prepped and put into this machine of coding capital, undermines, I think, our notions of democratic self-governance, and I would even go as far as suggesting that this might have something to do with the rise of populism and just the sense that I think many people have that the system is rigged, as former President Trump likes to say, but I think on that point he's not entirely wrong. So let me stop here.